So thank you everyone for joining the webinar on e-courts. So I'll just talk briefly about e.law and e-courts. We've been around for about 15 years and that's actually been part of our core business. My background is actually in courts. I worked in the courts in Queensland prior to starting e.law, and we started out assisting commissions of inquiry by putting the technology in. One of the first courts we ran was the Threadbow coronial inquest back in the late 90s, and we put all of the equipment in and ran and managed that particular electronic courtroom. And e.law as an organisation has been running these ever since. We can do small matters, you know, sort of 1 or 2 weeks in duration through to the long-running trials and also Royal Commissions. So some of our major matters include the HIH Royal Commission, the All Food Inquiry and the C7 litigation, and some of our more recent matters include the air cargo matter, which was heard in the Federal Court, and the Bank of Queensland matter, which was heard in the Supreme Court of New South Wales. We've also run smaller matters, including one in Geelong, which was a bit out of the way, and we're also involved in the Eastman inquiry in Canberra at the moment. So what is an e-court? It's actually a combination of equipment, an electronic library, which I'll talk a bit more about in a moment, but that's probably one of the key components of an electronic courtroom, and services to bring it all together. So the equipment that is used in an e-court includes an audio-visual display system so that the documents that are being displayed in the courtroom can be seen by everyone easily. We can put in monitors or screens for viewing evidence, and that will really depend on the number of people in the courtroom. A lot of the courts now do have some equipment, but if there's additional equipment provided, that can be put in, and it can include now things like iPads, which are actually becoming quite used. For those of us
I'm just going to say copy on DVD. Let's see if I can do anything in case.
I asked just put their phones on mute, please, because if we're rustling papers, everyone else can. So thank you. So this picture just shows you a typical court operating machine where we have access to all of the information on the tender bundle, email if it's required, and some courts actually have the ability to see and hear what's going on in the courtroom. It really just depends on how simple or sophisticated a courtroom is required to be. So the electronic library, there's a number of different software products on the market at the moment, and I'll talk a bit more about an announcement we'll be making soon in this area. But essentially the electronic library includes the tender bundle, and these days a lot of discovery is actually prepared electronically anyway. I mean, we're finding that a lot of the evidence that's ultimately referred to in court is created electronically in the first place. So rather than print that electronic evidence out, we take it in its original native format, process that for discovery, and it's all exchanged electronically. So it makes sense to keep that in its original electronic format and ultimately present it in court electronically. And often these days, the original native format will need to be displayed in court, particularly things like spreadsheets, where you might need to refer a witness to, the formulas in a spreadsheet. So it is really important that that original stays in its original state. But the tender bundle can include anything from scanned hard copy documents through to these what we call native files as well. And we take the documents that were prepared and exchanged during discovery from each of the parties and make that available through the electronic library as part of the tender bundle. The other thing that we do, which is really makes an electronic courtroom run smoothly, particularly for the judge, is hyperlinked witness statements. So as long as the document identifier, which is a unique identifier that's given to every document during the discovery phase, as long as that is mentioned in the witness statement or affidavit, then we can automate those hyperlinks. There is some manual work that goes in, particularly if the doc ID isn't put down properly, or sometimes because we're human, we don't put those down correctly, so our people then have to go through and just correct those. So it can't always be automated if there's those typos in there. But generally 90% of it can be automated. So that's really, really useful. A lot of the judges who we deal with find that particularly useful because they can just go through, read the witness statement, and whenever an exhibit is referred to, they simply click on that link and the image of the document comes up. The electronic library also comprises any of the exhibits that are attended during the hearing, and we can compile an exhibit list as the exhibits attended. Some judges prefer to have a exhibit number starting at 1 and continuing from there. Other judges are happy to use the original doc ID that the document was originally given. Obviously, if the fewer doc IDs that a document has, the better it is, because it's less confusing then. Some parties still prefer to renumber everything in the court book and then print it out, but we find that can again cause confusion because you have more than one doc identifier on a document if that's done. Transcripts, I'll talk a bit more about real-time transcript in a moment, but essentially the electronic library will include all of the historical transcript, and that is available for searching. These days we can get what's called marked up transcript, and that means things like whenever a witness is sworn, examined, cross-examined and so on, that's all bookmarked in the transcript so that a user can go to that point in the transcript very easily. If a document's referred to and the doc ID is read out in court, a link to that particular document can be put in. So you simply click on the doc ID where it's referred to in the transcript, and the image of that particular document will come up. There's also transcript analysis tools, which I'll talk about in a moment, but essentially the electronic library, as you can see, is from the tender bundle onwards, ultimately ends up as the court record. So everything that comprises a court record, including the transcripts, the exhibits and so on, will all be in the electronic library. So your pleadings will go in. Depending on how the parties or the court want to use it, you can add notes to pretty much anything in the electronic library, submissions and pretty much anything else that the parties or the court might want in the electronic library. I should say, if anybody has questions, I might just leave it to the end unless there's a pressing question, just because I've got everyone on mute at the moment, so I will leave time for questions at the end, so please just take a note of anything as you go. The other thing the electronic library does, or the software that we use, has what we call a public view. Now, the public view is really good to enable documents to be displayed using the software. We also enable, for those who've just joined us, thanks for joining us, and if I could just ask you to put your phones on mute, please. We just get a bit of feedback and rustling in the background otherwise. So the public view, as I said, allows the documents that are being brought up by the court operators to be displayed around the room. It also allows for users who want to log in remotely and see what is being referred to in court, because the software enables those documents to be published through the software to pretty much anywhere. You could be in the office up the road, you could be overseas even. And within the courtroom, we also have what we call a video display, so that the documents can simply be pushed out to terminals around the room as well. So what our clients have said is that the electronic courtroom really provides an advantage because of the fact that you can work externally from the courtroom. You can log in and see the documents published at any time. And I'll talk a bit more about the real-time transcript shortly. So real-time transcript, for those of you who've never seen real-time transcript or not too sure what it is, essentially what happens is the hieroglyphics, as I call them, which are generated by the stenographer's CAT machine in the hearing room. Normally the hieroglyphics are produced on paper, and then the stenographer will go away and transcribe those hieroglyphics into what's ultimately the transcript. With real-time transcript, those hieroglyphics are taken from the CAT machine and they're translated into text on the fly. There's a scopist who will correct any obvious or immediate errors, and then that text can be taken and viewed on user screens, generally a few seconds behind the spoken word. Now the benefit of that is that text can be fed into software and the real-time transcript can be noted up as you go. A huge advantage of that is that at the end of the day, counsel and instructing solicitors have the transcript already noted up, and that at the end of the day those notes can simply be printed out. You can also collate anyone else's notes, you can get together, you can talk about potentially what's going to be cross-examined on tomorrow. Now that's a huge advantage rather than having to wait for the transcript to be emailed or presented to you at night and then have to go back through the transcript to mark up and find out, or cross-reference with the notes that you've made during court. So real-time transcript does, I think, provide a real advantage, when you've got a hearing and you've got, witnesses who are in the box for any length of time. The services also include video conferencing. We don't get this a lot, but occasionally remote witnesses might be required to appear and provide evidence via video conferencing, and that's particularly useful if you have overseas witnesses who can't get to Australia very easily. They might be experts, for example, and as long as the court allows that, then they can appear and give their evidence via video conference. And it's just done in the usual way. The transcript will be done in the usual way. Some courts do have video conferencing facilities which we can use. If they don't, then we have portable video conferencing facilities that we simply wheel into the courtroom and plug in, and away we go. The court operator. I like to call the court operator a virtual judge's associate, if you like. They sit in the courtroom and they bring up the documents so that they can be displayed around the room really quickly. And then, of course, we have technicians available in the courtroom for any technical issues. I always like to say that for any technical issues, we should be able to say to the judge that, within a space of 5 or 10 minutes, they will be fixed. Luckily, we've never had, touch wood, a technical issue that has meant that we've had to have any downtime, but really it should be able to be fixed very, very quickly. So our court operators are trained to bring up documents very quickly. It benefits a lot in that if you can imagine sitting in the courtroom, and I think I'll give this example in one of the later slides, where if you're referred to a document in hard copy, then everybody then has to find that particular volume, that particular tab and that particular page. And that can take a little time, whereas a court operator, as long as the doc ID is referred to, they can bring that up pretty quickly. And that in itself can save an inordinate amount of time during the hearing. So what does an electronic court look like? This is the electronic courtroom that we set up at QUT a few years back. The courtrooms haven't really changed much during the time I've been doing these in the last 15 years. And as I said, they can be as big or as small or as sophisticated or as simple as you like. But I like this photo because it gives you sort of the idea of the technology, and then the counsel with their wig and gown in the traditional sense, juxtaposed against the electronic systems in the background. So what are the benefits of an electronic court? Well, these days more and more discovery is being prepared and exchanged electronically, and as I said, often the reason for that is simply because everyone is creating and exchanging emails, more so than hard copy. The information exists electronically, and it makes sense to obtain it, exchange it and present it electronically. In our experience and talking to our clients who've used electronic courtrooms and talking to judges who have been involved in matters where they're run electronically, having the documents called up and displayed electronically can save an enormous amount of time compared with using hard copy. And this is the example I give. So traditionally in hard copy, you'd have everything in folders and everybody would have their own copy of those. So counsel may say, I refer, Your Honour, to a letter of Joe Black to Mary Smith, the 4th of April 2004, which is in folder 32, tab 3, page 15. So everyone has to stop and find that particular page, and that can take, I guess even sometimes up to 30 seconds. Whereas in the electronic world, counsel will simply say, I refer to document identifier, for example, abc.043.089.0345. The court operator locates that and brings it up, and that's done pretty quickly. Now, the other benefit of referring to a doc ID is that that number is read out, it's put into the transcript, and the court operators are trained to put a particular, the court transcribers are trained to put a particular mark in front of the doc ID, and as long as that's done, then within the transcript there will automatically be a link to that doc ID. So when you're reading the historical transcript and you're reading through, you can click on that doc ID and up will come that particular document. So it saves enormous time by simply referring to that standard method of identification for documents. So time saved can equal shorter hearings, which ultimately can end up in cost savings for your client. So when is an electronic court used? Well, it can be used pretty much for any matter. It can be used for large matters or small matters. So, for example, here on the left-hand side, that was the HIH hearing room, which was a custom-built hearing room, very large matter, long hearing time, and obviously the volume of documents and the length of time, the technology really helped in that case. However, it can also be used for smaller matters, and on the right-hand side we have a small courtroom where we simply set up laptops for people to use. That was run as it was only a very small matter. The technology was very basic. People could just go in, access it and have everything run quite smoothly. So in a recent matter that we ran, it was a relatively large case. There are about 50,000 documents in the tender bundle, 300 affidavits, all hyperlinked exhibits, 100 sitting days. RealTime Transcript was used along with the electronic library with a public view and a court operator. So that matter ran very smoothly. The technology that we used remained flexible, and we're able to provide the service for the client that was required, and that resulted in a very smooth matter for both the parties and the court. We've also done small cases, so a matter that was only a couple of weeks in duration in Geelong. We didn't use a electronic library as such there, we just had the documents in PDF, and these were simply displayed using a very simple visual display system. We sent a person down to Geelong, and that person acted as I guess the person who set up the courtroom, liaised with the parties, assisted with any technical issues they would have had, and also acted as the court operator. That worked very well. The parties, again, were able to were able to use the technology, and notwithstanding that was only a relatively small matter. So what are the courts saying about electronic courtrooms? In the federal court, that court has issued Practice Note CM6, and all of the other state Supreme Courts have similar practice notes, although I think the federal court one is now has the latest practice note, so it is perhaps a bit more up to date. And it actually has a pre-trial checklist. And if you go to the Federal Court's website, and I've got the URL on that screenshot there, you can actually obtain a copy of the pre-trial checklist. But essentially it says, have the parties adequately addressed the issues in the pre-discovery conference checklist. So in other words, you need to have gone through the process of discovery. There is a checklist for that discovery. You do need to attend a pre-discovery conference and go through the steps that have been agreed during discovery. The court will ask, have you actually done everything that you needed to do in that pre-discovery conference checklist? Have the parties engaged suitably qualified providers to facilitate an e-trial? Is the judge happy with what the parties are proposing? Is there enough support for the court book and contents throughout the trial? Have the parties considered what transcript they're going to use, including options such as real-time transcript? Have the parties addressed the hardware and software requirements for the courtroom, including court operator services? And finally, have counsel been appraised of the need to refer to document IDs? And that's quite important. And in fact, that's probably one of the key things that really makes an electronic courtroom run smoothly, is the ability to refer to doc IDs for the reasons I mentioned earlier, which is that those doc IDs can then not only allow the court operator to bring the documents up quickly, but also have those links in the transcript. So what does the courts provide? 15 years ago when we started out doing this, most courts had nothing. I think we set up an electronic courtroom in one of the ceremonial courts, and it only had one PowerPoint, so we had to firstly get some additional power. But these days, a lot of the courts are becoming modernised, and they certainly have the basics now. Certainly the matters that we ran recently in the Federal Court and Supreme Court did have screens, cabling. They do have Wi-Fi, although we tend to recommend that dedicated broadband access be available in the courtroom. In our experience, Wi-Fi, can be slow, or there can be issues with it. And when you're waiting seconds for documents to be brought up in the courtroom, every second counts. So dedicated broadband is something that we put in, and it's not that expensive. Broadband is something we all use every day these days. And the court staff are very knowledgeable and accommodating. Whenever we need to set up a courtroom in any of the courts, the IT staff are very, very helpful. So what does an electronic courtroom cost? This is always a question. I guess people say, well, we'd love to do that, but, really, it all comes down to the numbers. Obviously, it depends on what's required. For long trials, then, more equipment may be required, and it may be required, obviously, for a longer period of time. A rule of thumb is generally it works out to be probably about $1,800 a day for larger matters, including the court operator. Now, if there are 3 parties, for example, that brings the cost right down. Similarly, real-time transcript is around $2,000 a day, and again, if there are 3 parties, then the cost is down to about $700 per party per day, and that's actually less, I think, than daily transcript, because with daily transcript you have to pay that cost, I believe, per party. For smaller matters, though, we can provide a fixed price per day, and we can really pare it right down to just the basics. So it can be anywhere down to as little as $200 a day, depending on what it is you need. So obviously, when you look at all of the other costs that are involved in going to trial, counsel's fees, sometimes the court charges a fee these days, solicitors' fees, and so on. The added cost of the electronic courtroom, when you look that it may actually save hearing time, certainly is certainly worth it. A question I often get, particularly by, I guess, counsel who are used to using paper for cross-examination. What if I still want paper in the courtroom? Well, then of course we can still make hard copy available, and often counsel will prefer to have paper because that's the way they've always worked, and my belief is that counsel shouldn't be expected to suddenly change the way that they practice simply because the matter is being run electronically. I mean, their job is to cross-examine the witness and to get them to say something that is helpful to their case. So if counsel want paper, then it should certainly be made available, and certainly if a witness prefers to look at paper, then that should be made available as well. So we can certainly generate that, but an e-court's about having paper on demand rather than having everything in paper just in case. So instead of having 200 volumes, if that's what comprises the tender bundle available, then you just have whatever you need for that day's hearing. And in fact, in HIH, I know it was a few years ago now, but when that courtroom was built, there are actually alcoves built for lawyers to come in and bring their trolleys with paper. And in the end, that was never used because people actually would just bring in what they needed for that day because everything else was available on the system. And if you needed a document that you didn't have printed and it was available on the system, then that could be printed out very easily. And again, in e-courts, if you do need to produce that, then we have printers available either in the courtroom or very close to the courtroom, so it can always be provided if need be. So how do you plan for an electronic courtroom? So to minimise the time involved in preparing a matter to be heard electronically, I think there's a few simple steps to keep in mind. Firstly, prepare and exchange discovery in an electronic format using the Federal Court CM6 as a guide, or if you're in one of the state Supreme Courts, have a look at that particular practice note. If you just go to the website, all the courts will have those practice notes available. Usually there's an agreed protocol agreed between the parties up front in order to prepare and exchange discovery, and ultimately if you do want to run a matter electronically, you should talk about that as early on in the proceedings as possible. I can't stress referring to doc IDs or the importance of referring to doc IDs enough. That's particularly important. The preparation of the witness statements and affidavits with the hyperlinks really make a difference once you go to trial. They do save an enormous amount of time. Obviously you need to get the consent from the other side, and you need to get the court to approve to have the matter heard electronically. If we've been involved in matters where one side does want to run the matter electronically and the other side doesn't, in which case the matter's taken to the court and then the judge will decide how the matter is to be heard. And understand, I guess, what is required and plan for everything as early as possible. If you're not sure, then obviously get qualified experts, get a quote, and also ensure that you're going to get round-the-clock service. In my experience, all of these trials are moving feasts. No tender bundle is ever fixed at the beginning. There's always work to be done, at night once the matter is adjourned for the day and there's other issues that become apparent. So to have that work needed when you need it done is particularly important as well. And finally, get a contract in place. We always have a contract with the parties, and that sets out our service level agreements with the parties and also with the court, because we're in a unique situation where although we take instructions from the parties and the parties pay us, if the court or the judge says that something is to be done, then obviously whatever the judge requires takes precedence. So today I'm not going to give you a demo of the software that we have been using for the electronic library. We're about to launch some new software, which is quite exciting, and we will be demonstrating this in about 3 or 4 weeks. So we'd invite you to again join our webinar at that time and actually have a demonstration of this exciting new software. What this software will do is it will enable same issues to be assigned to both transcript and documents. It will provide sophisticated hyperlinking between documents, and it will also show the relationships between the hyperlinks within documents. And what I mean by that is if you're interested in a particular document and you want to see which witness statements and parts of the transcript that those documents are referred in or referred to, then you can get a list of those and very quickly get an overview of how the information relates to each other within the electronic library. Users will be able to mark up documents and put their own notes in on both the transcript and the documents in the tender bundle. Drag and drop capabilities. These days it's really important that parties be able to get information in very quickly and easily. And it also has the look and feel of a hard copy tender bundle, and we find that counsel really like that. It means that counsel are a lot more comfortable using technology if it does sort of go some way to preserving the way that they've always worked. And the other thing we really like about it is that it enables easy renumbering for tender bundles that you may require printing. And what I mean by that is, everything might have a doc ID, but then when you come to print the tender bundle, it often needs to be arranged chronologically, keeping host and attachments together, and then parts of it printed out, whether for counsel, for witness, or for the court, or just the tender bundle generally. And often we find that documents may need to be added in to that tender bundle, and it needs to be put into the correct place in the chronological order in which that appears. So that can all be done easily within the software as well. So as I said, we'll be holding another webinar next month, hopefully in about 3 or 4 weeks, and we'll send an invitation out to you all to see a demonstration of that new software. Okay, well that's an overview of e.courts. I'll now turn it over to anybody who has any questions or comments. Oh, that's good. Hopefully I explained it all relatively easily then. If anybody does have any other questions or queries, that's my contact details. Probably the best way to contact me is via email. And my email is a.stanfield@e.law.com.au. So please feel free to drop me a line if you would like any further information or would like a copy of the slides. Just email me and we can certainly accommodate any queries that you might have. Okay, well if nobody has any questions, then I'll let you all get back to your day. Thank you very much.